welcome back to the House Judiciary Committee this Thursday afternoon, January 29th, and we're going to continue taking testimony on H578, and we are lucky to have Lisa Mylott, the Director of Animal Welfare, back to talk with us. If you could join. Thank you again for being here. I appreciate your help with this bill.
I appreciate the invitation. I am going to have my laptop open if that is okay, because I don't have anything printed.
Absolutely.
Late this came out, but so I'm Lisa Mylott. I'm the Director of Animal Welfare for the state of Vermont, and I'm very happy to be here with you all today to talk about the revisions to H578. And I know that you guys have been putting a lot of time into this, and so I'm going to try and be fairly concise, but definitely ask me questions. Let me know how I can help you. So I can go through some of my line item thoughts on the bill, but there's two big picture things that came up this morning that I just wanted to lay out, because I think they're tensions and they're policy questions, but they're for you all to decide. And I think that you're grappling with the right things as a law professor and as a animal welfare expert. I think a lot of this is difficult. And so one of the things that I heard you asking about is the tension between having the ability to care for your animal and being allowed to keep your animal, because those things work together. Having an animal, of course, is a choice, and there are costs, necessary costs that come along with that. But at the same time, we don't want to say that just because you don't have many assets, you can't have an animal. And so one of the things I heard questions about is, how do you deal with the fact that where an owner cannot pay for the cost of care for their animal, somebody is going to lose out, because it's going to be the vet who provided the care and can't collect from an owner. It's going to be the Humane Society that has been providing care for the animal and now is not getting reimbursed. Or it's going to be a municipality who is responsible for putting up that animal and isn't going to get the money back. And these are all tensions, and I have to say every state struggles with them. The cost of care bills are intended to try to put the burden on the owner to the extent that is possible, and to the extent someone cannot pay for the cost of the care for their animal, to strip title, so that they no longer can have that animal. The animal cruelty law itself sets up an obligation to pay for food for your animal and to pay for necessary vet care for your animal. You are committing cruelty if you do not do those things. And so that is the core part of the security under this bill, would be requiring you to pay for these things that cruelty law already requires you to pay for. And so when you say that that is possible to be waived, you're saying that the person doesn't have to comply with the basic care obligations for their animal. And so that's just something to keep in mind when you're balancing these things. We're not saying that with the security, it wouldn't be a question of putting in for boarding or for things you might not have to pay if they were in your house. It's simply putting in money to pay for food and for necessary medical care. And so to the extent a judiciary is saying, owner, you don't need to do that, it's basically saying that you don't have to provide non-cruel care for your animal. And it is putting that burden on somebody else. Somebody else is necessarily paying those amounts, and there's no fund for that. There's the Animal Welfare Fund, for example, where payments are coming through, has no excess funds and actually will be in the negative come this summer unless other funding mechanisms for its current obligations are identified. So I just want to put that out there. And this is all tied in with your due process discussion.
That's a good question.
Yeah.
Because I appreciate you bringing it up. I hadn't thought through that. And as you're saying it, it's making me think, yes, I get that that is something that's needed, is to pay for food and for the animal care. I feel like the original owner could say, well, but I could get the food from some other means, or I could get it at a lower price, or I barter for it, which is very different than this sum of money right at that moment. So I just hear that, and I feel like there's room for navigating that. It could be the other side of it too.
I think that's right. They could be going to a pet food pantry, for example, for the food.
Yeah.
It might be, though, that necessary vet care is something that you don't want to allow to be waived. If somebody's dog, for example, has a broken leg, they are obligated to get vet care, to surrender that animal, or they are in violation of criminal law. And so it might be that one way to think about this, and once again, you'd need to decide what you want to do, is to say that the judge can waive the food part. So where the animal doesn't need vet care, you can waive the entire security.
Mhm.
But where there's necessary vet care, being able to pay some amount in, and that's, I don't mean the normal cruelty exam. That's not necessarily necessary vet care. But where there's therapeutic needs of the animal, and that's part of it, it might be that you want to parse through how much of it is waivable. Just, or it can all be, like, it could be that you decide that these things are better borne by a nonprofit or by a municipality, and we would rather put the burden on them. And that is perfectly, like, that's your choice. But I just wanted to make sure that that those elements were thought through, but I think that's a really,
And I
Good
appreciate,
point.
just appreciate the message that we're talking about animal cruelty, but then we're saying, but in some cases, it's okay if you don't have. So I appreciate that. And I just want to broaden it that there can be different ways people can get the food and services and.
yeah. Yeah, no, especially with the food. I mean, there's great organizations to help with that. And so you're necessary vet care, it's a little bit harder to say there are ways around that.
There's another question along those lines here.
So I was sort of wondering the same thing because I know that even some places where you board your dog, they say, bring the food. So I don't know if one option, and I'm sure it's very different for horses or cows but like for cats, like it's like, here's the food I bought for my cat this month. I'm sending that along because I already put my money out for that, which I don't know if that would be allowed with our legislation. And then I'm thinking about the situations where you were saying necessary medical care, and it might be because they have not been feeding their pet, and for whatever reason, neglect, cruelty, in which case it seems that they can't have, like, returning their pet if they're not going to be able to feed it is going to be an issue. And I don't know, again, in the child abuse situation for neglect, right, we would try to connect them with resources and see if, can we work it out so that this is temporary and we don't have to rehome your child because you can't feed them.
Right.
I'm just wondering if you think this bill allows for somebody, and again, I don't know if that's like a weird situation to send the food along, if that's an option, like I feed my dog, science guide every day, and I don't know what, the caregiver is going to do, but it's probably better for the pet to.
It depends is the answer, because the truth is it's going to be a higher burden for the caregiver, because now they have to have this outside food and store it in some place that, for example, rodent-free storage
Right.
in a place that already has stock food probably. And so you're creating a higher burden on a caregiver. And so with respect to the food, I think it makes sense probably that could be something that, I just want to push back just on the medical care, though. I think that is worth thinking through whether you want both of those waivable or only one element, because there will be cases that don't have necessary medical care. For example, if they're being seized for conditions, animals that are being housed outdoors right now without appropriate shelter, without insulated or heated shelter, that animal is not going to have necessary. They're going to need a cruelty exam, but that's not medical, that's not therapeutic care, right? And so in that case, maybe waiving the whole security makes sense. It's only about food, right? And maybe they could have gotten it elsewhere if they have indigency issues, but if that animal has a broken leg,
Right.
that seems like a different category, and it's also a different quantity of expense for the caregiver, because generally the vets are not going to bill that owner individually because they're not going to get paid. And so that vet will stop working with the impounding organization if the vet is told, bill the owner, because every one of those is going into default.
And is necessary vet care pretty clear? Because like as a pet owner, my cat had a tennis elbow and my vet was like, we should x-ray her, but I have felt it and I don't think it's broken. I'm like, well, what will we do if we have an x-ray? And she said, well, probably nothing. I mean, she didn't.
Yeah, right.
So it's like, well, it wasn't necessary, am I denying necessary care to my cat if I'm not getting an x-ray right away?
I think that is a drafting question because the language in the cruelty statute, I had to look back at it, is not exactly necessary vet care. And there's case law on what would be required as opposed to what's discretionary, right? And and so I think that's a drafting question, but I think that could be effectively drafted because I feel very strongly that actually that things like the cruelty exam should not be billed through to the person unless we know that they've actually, until we get to the criminal conviction stage, right? And so I think drafting that language is both doable and there's examples out there of what that is since there are legal requirements and and would be important.
Especially to pet owners too, to know when they're, like, I don't want to neglect my pet.
Right.
Yeah.
Yeah, I agree. I think that's a good. I think these are all really hard questions also, right? Because of the human animal bond and because of the importance of and the fact that animals can't talk, right? So we don't know about suffering. So there's a lot of nuances here that I think you guys have important decisions to make about. And all of this is tied into the due process.
Yeah, could you tell me where the waiver part is in the bill? I mean, are you able to point out where we would be?
For
Page 24, lines 3 and 4.
Thank you. Waived by the court, okay, on the basis of financial hardship, but this is where we
Make a
would,
decision.
you could distinguish, or you could leave it like this, or, yeah.
So can I just ask it just to make sure I'm understanding the level of exposure of the caregivers as well? So the way this is set up now is that with the change to 14 days that we talked about this morning, is that an animal is seized and there's service hopefully at the same time, but the service is tied to the 14 days. So you have 14 days, the person will often, from your experience in Minnesota, from what I understood, won't bother to contest. And so that's taking care of things because they can dispose of the animal one way or another, adoption, whatever.
But they do have to put the money in Minnesota. There's no waiver possible in Minnesota of the amount in order to just
in Minnesota. Right,
yeah.
Right. No, I understood that. So if they do want to contest it within 14 days, they get a hold of court, and then 30 days, they have the hearing. And that's a hearing to determine if the animal is going to be forfeited. And then you look with that at that hearing within 30 days, hopefully sooner than 30 days. The state actually has lower burden of proof as well, a preponderance of evidence that the animal is subject to cruelty.
Right.
And presumably, if they're unable to meet that burden, the animal goes back, there's probably not going to be a criminal case because you haven't even been able to meet preponderance of the evidence and it's over, or they do meet it. And so there's really just like a 45-day best case scenario. Maybe that's not the best.
Oh, I want to say worst case.
Oh, worst case. All right. Worst case scenario, I should say, the 30 days, the 14 days. If worst case scenario as far as the exposure. Am I understanding that right? I know that's still money and it's still cost, but I'm just trying to make sure.
With the caveat that it could be slightly worse if there's an appeal, for example, right? So that's just to get through the trial of the preponderance of the evidence. If the court finds that the state met its burden of proof, then the defendant can still appeal. But it's less likely that's going to happen a lot. And so odds are it's going to be taken care of in 14 through 45 days. Yeah.
And it's at that 45th day or earlier that the security or the money would have to be provided. Is that?
No, for this, the minimal amount, the food and the necessary vet care amount needs to be paid in the first 14 days. So it's to get that hearing.
Okay.
And part of that's intentional. So if somebody can't provide that necessary vet care, for example, then they shouldn't get the animal back. And so they default at that point.
Okay. All right.
And I do want to say there was a case, I think it was 1995. Minnesota had an earlier version of the statute they have now that this is modeled on. And in 1995, their statute said that title was forfeited in 7 days unless the person put in the actual cost of care, which includes boarding expenses and things like that. There was no provision, though, for a hearing or for explicit notice. And so there was a due process claim brought against Minnesota. Minnesota lost. So they revamped their statute, and their statute they have now is either from 2000 or 2001. And it provides for the 10-day default unless the person requests a hearing and puts in the actual cost of care with no waiver
We have that
potential.
here, and I just.
Without the waiver, yeah, so there's no, and there have not been further due process concerns with that statute in the subsequent 24, 25 years. And there are, just about every state has some version of cost of care statute where people lose title if they can't put in the money. And there are no cases finding that those violate due process. So I just want to put that out there. You've got ledge counsel, who is your counsel. But just on the animal specific point, I think it's ultimately the answer is I think it's purely a policy decision for you all and less of an outside one. So it's about policies you want.
But you've given us some good nuance as far as they can't pay for at least the veterinary therapeutic care. Should they be keeping that animal? Or should they have, should it be forfeited right there? But if it's the food, then maybe there's.
Yeah, then maybe there's good argument that.
Again, has the revamped Minnesota law from 2001 been challenged?
I didn't see any evidence of that. I dug through it last night again and just the 1995 to 1998 appeals stage, but it's just the new.
All right.
Okay. Then going through the draft more on a page by page, although I start on page 9, I don't really have much specific before then. I know you guys are dealing with the definitions of cruelty and what exactly counts. And I think the considerations there, but on page 9, if we look at cap CI, so for the first violation of section 352, with each of the things in CI, C2I, C3I, question is whether or not you want to include domiciled with. In the earlier section, I think B, you include it. You didn't include it here, and so I'm just wondering if that's.
So I think we're including that and we're adding the work with.
Yeah.
So yeah, thank you for.
And that would also be page 11 EI, page 11 D1, and page 13, line 7. And maybe Eric can just do a global find and replace, but that's
Just
what
add the doctor.
yeah, that's just what I noticed there. And then page 10, page 10. Okay, now I'm not seeing the page. Okay, where it's talking about having reasonable visits in the period after the prohibition period. So where someone's prohibited from having an animal for some period of time, then there are reasonable visits in the year after that to make sure that everything's fine. There should be reasonable visits during the prohibition time as well to ensure, if you want that to be enforceable. You've got the great enforcement mechanism like the SA was saying, but and I have to look back at the number because it doesn't match up with what's on my screen right now. And you might want to consider on page 10, section F, which is the prohibited from working with, in addition to the point about for-profit businesses, you might want to include volunteering for these ones. Just because humane societies and rescue groups aren't running background checks regularly. And so if it gets caught, it would be nice to have records. And this is a point from last time on page 12. If we look at 3C, in determining whether to approve a petition to remove the disability. In C, maybe it should be whether the person successfully completed an animal cruelty prevention. And I know that got picked up from earlier, but I just wanted to flag that.
Can we back up for a second as well? I'm back to page 10 at the top as far as the period, the visits. So State's Attorney Brown raised the issue of whether or how that could be enforceable. Do you have any opinion on that part?
I would defer to him. I'm happy to think about it. But in terms of the mechanics of the criminal law enforcement, I suspect the essays.
Yeah, I just wondered from other
Either in this
states.
room or elsewhere.
Yeah.
I can look at that.
Okay, thanks.
So page 14, line 5. This is a point that was flagged by investigators for me. It's talking about which animals can be seized as
Tell me
part
where
of,
that was again?
sorry, page 14, line 5. That tells us that any humane officer may enforce this chapter as part of an enforcement action. A humane officer may seize an animal being cruelly treated in violation of this chapter. Being cruelly treated is a legal conclusion, and we don't know that they're cruelly treated until we get to court and we determine that they were cruelly treated. And so one option that you might want to consider, and there would probably be others, would be instead having language of something like seize an animal as part of an investigation into a violation of this title. And I'm saying violation of this title, not the cruelty statute, because there are actually other crimes against animals in the title. And so having it be slightly looser because it's part of the investigation and not having this legal conclusion of cruelty treatment.
So what's that language again? Or
What about, so seize an animal as part of an investigation?
seize as an SEIZ?
Yeah, SEIZE. An animal as part of an investigation into a violation of this title.
Part of this title, or is that what you said?
In violation of this title, as part of an investigation into a violation. So the investigation triggers the right. And they're gonna have a search warrant, or they're gonna have exigent circumstances.
Yeah, question.
Yeah, but isn't the seizure for the purpose of like relinquishing, like taking ownership of the animal because of the cruelty? And that's why we're working on trying to expedite this process. If it's more of like seizure for investigatory, like can we already do that? Can we just seize animals in the sense that they are evidence in a separate process? I guess I'm just merging them in sort of just like an investigatory tool. Kind of, we're going down a path of a procedure here after that that's like all about taking the animal because it's been cruelly treated, and that's why we're trying to move this more quickly. So if we're kind of shifting that from the animal's cruelly treated to like we just need to seize this animal because we're doing an investigation, then why like should we have such a fast process beyond
Right. So other option is to, I think, get at both these things is why can't it be? I think you get the legal determination because you say in violation of this chapter. I mean, isn't there some common sense of an animal being cruelly treated? In other words, just have it as part of an enforcement action. A human officer may seize an animal being cruelly treated, period.
Well, part of the problem is you're not sure at the moment of seizing. So I'll use an example of somebody who has 2 dogs. And the person beats one of them up, and that's known. And an officer intervenes and wants to seize animals, but he can only, under this, he can only seize the one that is currently being beaten up. He can't seize the other one to see if it's got contusions. Or in a case with a horse, there's the horses, one horse seized was because, well, they had to determine on the ground that by a very high standard of proof that each of these animals being seized was being cruelly treated, but there were other animals that there were visible signs of severe neglect, but they weren't sure it would rise to cruelly treated, so they couldn't seize those because of this language. So that's what's been flagged for me by the investigators and their concern about. Right now, they feel constrained to only take the animal, for example, with the open wounds, not the one that with a husky, you're not going to know if it has any problems until you shave it.
Right. But so this isn't an emergency seizure?
This includes search warrant seizure. It includes voluntary surrender. Well, which doesn't matter, but 2 is for a search and seizure using a search warrant. So that's not an emergency seizure. That's a
How about B at line 3 to 5? What kind of seizure is that? Is that a seizure without a warrant?
That's sort of just establishing the different types. Search and seizure, using a search warrant, search and seizure without a search warrant, voluntary surrender, right?
So,
It
yes,
seems different. I mean, if it's a warrant, if it's like an emergency seizure, that seems odd to say that it's as part of an investigation into, like, along the lines that Ian is saying. And so I guess the questions I have for our legal counsel as well is, where do we start running to due process concerns if we have an enforcement where there's a reasonable cause to believe that an animal is being cruelly treated or something along those lines?
that could work too, like reasonable cause to believe an animal is, or part of it is there has to be a what, like the person's not physically beating them at this moment, but was 5 minutes ago, right?
Well, or is in threat of, I mean, we can play with that language. a little
Danger.
bit, right?
Yeah.
So,
Yeah, I think that's great, and I think your counsel can probably come up with better language than
right.
I am, but it's the concept of investigators want the ability to seize more than just the animal that they can say unequivocally was fully treated, because this is an investigation into a crime that's a little bit broader than. And then we take care on the other end by saying, if there was no probable cause to seize that animal, you're getting whatever security you put in back, and you're getting the animal.
But we're in the civil, aren't we in the civil seizure here?
No, this is still criminal, and then we go into civil title forfeiture, but this is about the criminal. This is 354 and 13 VSA.
Okay, so we're still in,
Yeah,
okay, so we're all talking about seizing the animal, either emergency or non-emergency in the only in the criminal context, huh?
this is there's no authorization for civil seizure of animals. So for example, if an animal is outside in this weather, a short-coated dog outside in this weather, tethered out, and it's currently 20 degrees, so it's arguable he's not being fully treated at this moment. You would like to seize that animal and say, let's hold him and make the owner fix circumstances, but let's not have him out at -10 tonight. There's no provision for that, actually. And so in my comprehensive plan, I suggest that we look at this and think about what would be helpful in terms of expanding the civil protections and the civil ability so that we can prevent things before they get here. But that's a conversation for a different year. So yeah, this is about criminal seizure, but then we have the civil forfeiture process because to strip property title.
Which kind of gets to Tom's point about they're basically always going to be being a criminal with the civil, because if there's no civil, I guess I never really understood that complexity of this, that basically the only way you get seizure is through criminal investigation.
Yeah.
So you're holding them based on the criminal conduct, but then you can move for the civil forfeiture while you've got them.
Yeah, the only impounding for non-criminal process that I've seen is running at large. Dogs running at large can be impounded, right? And that's not the same sort of process like this, but it doesn't fall under the statute either. And that's only if your jurisdiction has that order.
So how does that work with the notice? Okay. Sorry, I'm not trying to.
Yeah, okay, no, yeah, go ahead.
Um,
So we're gonna work on that though.
Yeah, there's that. I will be interested in seeing what you come up with. And happy I don't have to draft it. Then page 18, line 8. The court shall hold a forfeiture hearing if a request is made within 10 days after the seizure by a person claiming a legal interest in the animal at the time of the seizure. It might be a little bit clearer to specify and payment of the security under 3B. They have to both ask for the hearing and pay the security, or have it waived under whatever process you're determining for waiver. But instead of just, I think that it's a little bit, if I was reading this as a lay person, I would think all I have to do is make a request. Then page 19, line 5. And this actually should tie into the point we were just talking about with respect to which animals get seized. So it says the state shall have the burden of establishing by preponderance of the evidence the animal was subjected to cruelty, neglect, or abandonment in violation of section 352 or 352A of this title. And so I would suggest saying that the animal was subjected to illegal treatment under this title or seized in connection with another animal that has been determined to have been illegally treated under this title. So that would allow for, and that is a call for your part, but if a officer is seizing 19 horses, and one of the horses was seized lawfully as part of that. She had a foal that needed to nurse off of her, and the foal was cruelly treated. So the other horse was also, but there isn't the evidence that that particular mare was cruelly treated, but she's part of a whole collection that were seized at the same time. Do you want her title to be able to be forfeited too, or do you want her to have to go back? And so right now she has to go back, and this happened recently. This is a scenario that just happened. She has to go back because if you can't prove that she was subjected to cruelty, but she's going back to a place where there has been repeated rounds of cruelty seizures. And so things for you all to decide, and maybe Eric can give you some suggested language, and I'm happy to look at some too, but just how many of the animals are we stripping title to? Just the ones that we can point to and say, you had this particular thing, or since we're talking about title and discretionary ownership of animals, should it also be the other ones lawfully seized with with those animals?
And that's just, and you're talking about, and I apologize, I'm just trying to keep all of these different, having them in two separate courts and two processes. Because now I'm also realizing that basically we're kind of taking the discretion away a little bit about moving forward with civil forfeiture, because you're only doing it through the criminal seizure.
Well, not necessarily. They may still possess the animals that you're trying to get them forfeited.
But our whole timeline is kind of built around serving them with notice at the time of seizure on the civil thing. And so basically we're kind of getting, I'm sorry, I'm kind of going off but I'll bring it back. So you're talking about the civil forfeiture of animals outside of the animal that is sort of alleged to have been abused. You want to know whether we want to expand the scope to try to capture those in the civil side.
Yeah, if they were lawfully seized as part of the criminal investigation, right? So they were lawfully seized as part of that, and some animal in that bunch, it's been established in the civil case by the preponderance of the evidence, was cruelly treated. Should the other animals seized at the same time also have their title seized, or should they go back to that person? So yeah, it's a messy process, and it's different than other things that get seized, right? Because other things can sit in a locker and you don't have to feed them.
Because then there's probably an argument to be made that, well, if there's a pending criminal charge there where they could be adjudicated and determined guilty and it's their first offense, then the judge has the opportunity to, in our current language, to basically has the discretion to determine whether they should be foreclosed from having other animals than just the one that's abused. And kind of preventing the criminal side of it, kind of like preventing them from having the animals on this, like they don't have them anyways, but they never had the opportunity in the criminal court to essentially put on their case and potentially not be found guilty.
Because in any seizure, I would think not just because.
Or I might not understand that right. I think
you're right.
I'm trying to kind of, yeah.
But I think there's also enough times where a couple of the animals will get seized on day one, and the other ones don't need to be seized as part of the investigation, right? So all those ones are still with the person. That's where the judicial discretion will come in.
Yeah.
And it's just the ones that are seized. Yes, this does take away that judicial discretion on that end about whether or not the judge decides if they get them back or not. This is answering the question.
And in your experience is that the other animals that are seized, it's because they think they're being abused and they want to make a determination.
Yeah, so it's the ones that are borderline where they don't see the open wounds, they don't see the clear starvation with long-haired dogs or with goats and things like that, and with their winter coats. You don't know on scene because you have to shave them in order to know what's going on with their skin.
Yeah.
And so typically not every animal in a home is seized. It's the ones that have clear signs plus the borderline.
Okay.
But it's a policy question. How broad do you go in the protection of the animal? Or how much do you focus on keeping property with the person? And that's a policy. So.
Go ahead, Tom.
In your experience, you said, well, the way it is now, they only take the animal that's obviously being abused. In your experience, when people have multiple animals, is it common for only one animal to be abused?
It depends on the form of abuse. We see, it's like with children. So sometimes there are cases definitely where somebody chooses one of their animals to abuse and not the others. And I've had cases where one dog was starved, there is dog food in the house, the other dogs are healthy. But then in other cases where it's anger issue, a lot of the issues with animal cruelty are around anger issues, drug dependency, other mental illness issues, ultimately, right? And in that case, all of the animals are generally have some level of abuse. It just depends on which one has gotten it in this instance. And so it depends.
Okay. Ian.
Yeah, I just want to explore this very briefly a little longer.
Yeah.
So just okay, so let's just use your hypothetical. We got like 3 sheepdogs, 1 sheepdog, open wounds, easy to tell, cruelly treated. Other 2, suspicion, not entirely sure. We seize all 3 of them under just humane officer may seize animal being cruelly treated, right? We've got suspicion, so we seize all 3 of them. Now 10-day time period's running. Defendant, or in this case, respondent says, I want this hearing. So the hearing's done. Other 2 sheepdogs are shaved. 1 has wounds. There's now an argument to be made that this other animal is cruelly treated. 3rd sheepdog, no wounds, totally fine. Then wouldn't it just be basically at the hearing, either there's a negotiated resolution where 2 of the dogs are seized and the 3rd dog, which there's no signs of abuse, is relinquished back to the respondent, and like that kind of like sort of take care of that whole? Or are you saying, should that 3rd one that we seized, even if we didn't really have evidence, should we also be relinquishing that one?
That's ultimately the question for you. Yes, that is
Okay,
what
and I'm sorry, it was just taking me a while to get, okay, so
Yeah.
should that 3rd one, we got it anyways, we had that
Seized it
suspicion.
legitimately as part of the investigation.
Yep, yeah,
Right?
because there's suspicion.
But now we can't prove this one by a preponderance of the evidence was abused. And
Okay.
so should that one have to be relinquished if there's the evidence
That 2 others.
that 2 others were?
Okay,
And
thank you very much.
and it might be that you want to split these 2 things and seize slightly more animals, but only forfeit title to the ones that you have preponderance of the evidence that they were in fact treated in violation of the title.
Because if you're found guilty beyond a reasonable doubt, then you're losing, the way it's written now, you're losing all your animals. And you're not allowed to have any animals for up to some amount.
Well, maybe the judge has discretion about.
There's discretion on the first, that's true. Whereas this is just preponderance of the evidence to lose all those animals. So they're pretty different. Okay, all right.
Yep. This is just a nit, so, same page, line 12, that should be D. So line 4 has C, this is page 19, so C, and then follows over to the next page also with, 20, line 4, so, and down. All right, page 21, 6 through 10. So here, this is saying that if the defendant can't, so if the defendant wins the hearing, but there was probable cause to seize the animals, he has to pay the cost of care in order to the caretaker to get it back. He has to reimburse the person who's been taking care of his animal to get his animal back. Typically, at that point, if the person doesn't pay that money within a period of time, that results in forfeiting title too. If you can't reimburse the Humane Society that has been caring for the animal on the other end, you typically lose title. This instead says if payment of the cost required by the subsection is not made within 15 days, the custodial caretaker's cost not to exceed the amount of security posted. I misread that. My first point stands. The second problem is not here. I thought I was having to pay things out from the animal welfare fund that didn't go into it, but in fact, Eric drafted that very nicely. So my first point stands. Generally, if you can't pay the cost of care, that's the bond or forfeiture, you do lose title. Just know that that's not what you are doing in this part of the statute. And you might want to think about whether you want to do that.
And that's the cost of therapeutic veterinary care that we're talking about.
Typically, it's the full cost of care, but it could be very much divided. You, once again, that's your
Waiver
choice.
for the waiver.
Yeah, it could be, once again, has to provide that therapeutic amount. But the rest could, the boarding and the food could be waived. But typically the person doesn't get off with getting their animal back and not having to pay the actual out-of-pocket cost of the caretaker.
Can I ask one question on that?
Yeah.
So is that from Minnesota as well?
That's actually universally, that's the 40 states that have cost of care type bills. They all have that sort of provision where you lose title if you don't put in the actual cost of care at that point.
Okay.
And so that's just,
So they just don't allow waiver. Is that what I'm?
but other states don't allow waiver. Doesn't mean you shouldn't, but other states don't.
So the tricky part of it, right, is like, as I'm trying to understand is, so we're proposing to lower the civil standard to preponderance of the evidence, and we are waiving hearsay. And we're saying that the state cannot prove with a preponderance of the evidence and with no hearsay, or with hearsay exception, they can't prove that the animal was used. But the individual can't pay the cost of time that the animal was held. They still forfeit.
But you can find which, yes.
Yes, that's
First of
what,
all, I think the waiver of hearsay was in the original bill. I think it's showing as added because the original stuff is all deleted out and then add. But I think the waiver of hearsay was in the current statute.
I don't know. The current statute has like affidavits are admissible. I don't know if it has.
Yeah, and that's the same.
But anyhow, but so just to understand that that's so, yeah, some amount you can't pay, you forfeit.
Yeah, and it might be that you wanted to find a very clear out of pocket, so not caretaker cost, not space cost, and maybe not food cost, but out of pocket medical therapy cost as being bottom line. Yeah.
Okay.
Other states don't have the waiver possibility, just so you know that that's the general practice. And then page 20.
Angela.
I just want to, I'm really stuck on this, and we've heard it a number of times that other states don't have the waiver possibility. How is that not penalizing poverty?
Because there are baseline expenses that go along with having an animal. And so unlike a car where you can have your car, you can't drive your car actually without paying some amount. So you can't get to a job without paying registration, without inspection, without your driver's license. There are fees associated with many things in order to actually, in those cases, have them be useful. And that here, the animal's use is in your home. So it's the same sort of concept where it's not penalizing poverty, but it's acknowledging that some things are not necessarily a right, but a
Privilege.
privilege. And caring for another life. And we know that all the animals we're talking about are considered sentient beings. They can feel sensations, they can suffer. And caring for a sentient being is oftentimes seen as more of a privilege than a right. Just as driving your car is a privilege. It's not a right. And so there are expenses associated with exercising, making a choice, like having pets or having homestead animals, which are one of our huge categories of issues, is people who want to do homesteading but actually don't know livestock care. We just had this past weekend was a really interesting weekend because even though Vermont gets cold weather a lot, the number of cases I was juggling with animals, short-haired dogs, housed outdoors with no insulation, no bedding, no protection from the elements in wire houses effectively. So absolutely none. The homestead animals on a mountainside with no shelter, the horses in a pasture with no windbreak or constructed shelter, even though horses below 0 degrees by every standard out there need some sort of constructed shelter. The number of these cases that are happening are really high. And I think that you need to think about the costs to the animals if there's not some base level of care somebody needs to be able to provide in order to have them. Because, I mean, it's large numbers of animals. And when we talk about shelters for them, a constructed shelter, we're talking about 3 pieces of plywood, 4 pieces of plywood, or 3 pieces and a piece of tarp. It's not high standards, but the animals aren't getting them. And there are some animals. There are an awful lot of farmers that take great care of their animals. They are an investment. There are a lot of pet owners who take great care of their pets. And so we're talking about what should that minimum be? Should somebody have to be able to both think about the fact that this animal has needs to prevent suffering and then take actions in conformity with that? Because somebody will end up paying those costs. The animal will die, or it will be injured and untreated, or we're going to end up paying a lot of money as a state between our donors and our taxpayers for rehabbing these animals. And it's much more expensive to rehab than to prevent the problem. But it's really a question of how do you think about the ownership? Do you think it is a right where everyone should be able to have animals even if they don't feed them or can't feed them? Or do you think it's a privilege where we want to make this as accessible to as many people as possible, but we acknowledge that there are some people who will not have the resources for this? And that's why I'm happy you all are the elected legislators and not me.
And then setting that cost, setting that floor.
Yeah, defining which things are bare minimum do you need, and we have some of them in the cruelty statute already. They're not quite clear enough, and cruelty, I don't want to police ownership through cruelty. Like, I do think that having civil mechanisms that can intervene early, I'm big on prevention, would be ideal, but that's just not this bill. This is once we're at the point where animals are being seized for a criminal violation or suspicion of criminal violation. What do we do from there?
Again, this goes back to what we were talking about at the beginning. I totally get this. And I feel like there's a difference of what an owner might think is adequate care, type of food, a shelter, that kind of thing. And then what humane society, whatever their degree. And so I just feel like somehow got to meet that. And it's like, oh, I can't afford this, but I could afford this. And that's what I want to make sure is connected.
And I think that's a very real question. In vet care, it's called spectrum of care practice. So it's there's gold standard is what most private practice vets learned in vet school is like, let's do all of the diagnostics, let's game out all of these and see which one it is and then intervene. And then there's the fact that that's not accessible to a lot of people. And so their only option is to euthanize if that's what they would have to do. And so how do we think about, well, what is the minimum acceptable care? And that's where we are.
Yeah, so maybe maybe just how you said that, like it is the minimal acceptable care, like that is what they're looking for, not perhaps.
Yeah, we're not looking for gold standard, right? It's enough that the UK recently did a report because they're revamping their programs and it's their strategic plan effectively. And they define a life worth living, a life not worth living, a life worth living, and a good life. And so their goal is, to say the life's not worth living. That's where you want to prosecute people and deal with the issues there. A life worth living is decent, but if in some instances you're going to want to require a good life, right? Where somebody's discretionarily interacting with this, it's not a need in some way. But I think if we think about those things, which things are necessary so it's not a life not worth living, right? That's what we want to prevent is people treating their animals in a way where that life is not worth living.
Angela, do you want to?
Well, just to sort of full circle on that.
And I'm coming back to this
That's
too,
the-
so.
Yeah, so that's the question that's lingering in my mind is like, what is that? What is the minimum threshold? What is the minimum expectation? And then, resources for care. And then what's the gap between that minimum threshold and what most care providers would need? Is it the same? Maybe there's no gap, but if I'm just thinking, if we're setting in trying to solve a problem, I guess we're not really, yeah, like, I don't want to solve a problem by, like, I want to leave as the fewest gaps possible.
Yeah.
And so if one of the main problems we're trying to solve is the cost of care and making sure that caregivers are being made whole-ish. And but yet we want to be very cognizant of the varying abilities of people to provide for their animals and how it looks, it will cost different thing,
Yeah.
So I'm worried about that, not worried, but I'm just aware now of that tension and wanting to set a very reasonable floor. But then making sure that reasonable floor doesn't leave caregivers in the case of seizure, still be footing these big bills.
Well, I can tell you that the humane societies I've spoken to and the, basically everyone I've spoken to about this, that's sort of in this world, speeding up the time this takes is their number one priority because that's the biggest drag. You're right, there might be a gap between the care this animal was given and the bare minimum that the law would have required, and it doesn't seem right to make somebody put in the money for the gold standard if what they would have had to do if this animal was in their possession was this other one. And I think that's accounted for here, because when we talk about then the actual cost of care the person has to pay if they lose, that's something a judge gets to decide what was the reasonable cost of care. And that's when you make the argument that they went above and beyond. They plated that leg when they could have amputated, right? And a plating is going to cost you several $1,000s, and amputation might cost you $800. And they're both reasonable outcomes with a broken leg. And I ran a shelter medicine program where for animals at a municipal shelter in Georgia, I raised the funds and I made the decisions about the medical care they were getting. So I learned a lot from vets about, and there's a range of decisions you can make. And it might be that the Humane Society made the decision to place the leg. I never made a decision to place a leg. I couldn't justify the money. I had legs amputated. Those animals are living great lives. And so that's the judge. People get to make those arguments about, at the end of the day, then what is the cost of care amount this person will actually have to put in to get title. And that's an argument to make there. My intention, so you know, if for some reason you adopt this and there's going to be a scheduled amount that gets told to a person the day their animal's getting seized, is I would err on the low end, because I think that I think somebody being handed a bill for $5,000 because, maybe this leg needs to be plated, that's, to me, that doesn't seem reasonable. And you have a chance to look over schedules, as I understand it. If it's an administrative schedule being adopted by rule, like that would have some oversight. But I can tell you that one draft of this that's circulated, actually, I think that S-182, maybe not. One draft of this I had seen had a cap of like $250 for that security someone has to put in, based on caps on gun storage fees and impounds of cars. And that seems fairly reasonable for that upfront security as opposed to what they pay at the end if they lose the trial, right? And so I wouldn't think that, because the amount has to be calculable on day one. So when a humane officer is seizing an animal, he has to be able to write on that form how much money the person has to put in. It's not going to be particularized gold standard care. It's going to be, for a dog or cat, it's going to be $2 a day for food. Plus, if they clearly need therapeutic medical help, it's going to be $150, right? Something like that, where it's still constrained on the front end.
Yeah. That's what I was kind of going for, and knowing that you will have the person in your position, presumably, will have some authority to set this minimum expectation.
Yeah, and my thought always is that amount up front is going to be less than the actual cost of care. It's going to be a drop in the bucket. It is something to show the person is serious and they're willing to, and they're able to pay some amount towards caring for their animal, but it's not going to be a $5,000 bill. Once again, I would be fine having a limit, you guys can decide that, or leaving it open and knowing that you get to review what comes through, but that would be my
That's helpful, thank you.
thinking. I ran programs in Georgia where we provided free vet care to folks in systemically disadvantaged neighborhoods because I think that providing the resources is incredibly important and that there are a lot of people who don't have resources who can make very, very good pet owners. And they seek out help, that they show up for these free clinics, right? That's different from the person who doesn't take the advantage of the help.
I just had, so this is very helpful, and I appreciate you taking the long walk with us through all this stuff. So it sounds like the hypothetical that I'm thinking of is not what would happen, but I want to run through the hypothetical just to confirm. So state seizes cat, thinks cat is being abused, does veterinary care on the cat, x-rays, different things based on the suspicion, comes out, there isn't really anything there. The respondent contests, wins the contested hearing, no cruelty, is relinquished back. But boy, that x-ray, that blood test, that this and that for the vet care, that's like a couple grand. Taking care of a cat, generally speaking, is not that much money. And so like to say, right, like that like now suddenly someone who's, you know, paying for the cat food, doing the thing, now suddenly the state says, well, yeah, but we had to do all this vet stuff because we need to make sure you weren't abusing your animal. Now you need to pay that. We're not, because of your schedule structure, that would not be the case.
That would not be the case in terms of putting the money up front. You're right. There's no control on that on the tail end, except that the judge gets to decide what was reasonable. If the judge has said by preponderance of the evidence, there is no cruelty here, I can't imagine that judge approving that claim. And so maybe that's something that guardrails have to be put in, because to me, that's more the cost of investigate. That's evidence collection, right?
But the problem with us merging these processes even more than they already were, it's like they kind of are one and the same in some ways, right?
So maybe this is another time where we're talking about on the tail end, the person wins the case, what do they have to pay to get the animal back? Maybe you draft language that specifies the therapeutic vet care, because diagnostic is not the same as therapeutic. There's nothing on that other end, right? There are ways to break that down.
Yes.
And it might be that you want to put guardrails on what that person has to pay if they win that hearing. And honestly, that sounds reasonable to me.
Yeah. Okay. That's very helpful.
But on the front end, no, they would not be paid. I would not. have
That initial amount.
Yeah, no.
Yeah.
In order to get the hearing, I'm imagining it would be a relatively low amount, but not no amount.
I'm gonna do a time check right here. We're actually at time, but we can go probably for about 10 more minutes, because I believe what we're gonna hear from Judge Zone on H540 is not gonna take the full half hour. Judge Zone, does that work for you? Another, get to you in about 10 minutes?
Probably
Yes,
break.
absolutely.
Tea break.
What's that?
Yes, go for your break as well.
Well, I wanted to flag
Yes.
one more thing.
Thanks.
Oh,
Yeah,
sorry.
go ahead. Yeah, like one more thing and then we'll get.
So page 24, line 1, the time limits established in this section are not jurisdictional and may be extended by the court for good cause shown. I just want to flag that there's two sets of time limits in here. One is the time period, the initial 14-day period, after which somebody loses title if they're non-responsive or if they don't choose to have a hearing. And then there are the time limits in terms of the court needing to hear it, the case within 30 days. And
It applied just to the 30 days.
that, I think that's the intent of the language, but to me, it doesn't clearly say that.
Yep.
And so I wanted to flag that. But I'm happy to answer any other questions.
No more questions today, because we're gonna move to this other thing. So we're gonna have you back. I mean, when we have the next version of this, I guess if there are questions, if there's a question of if there's anything else on like section 6, which we didn't have you weigh in on, if you could, we can talk to you offline and if there's any language changes, we can get Eric. But yeah, we have a number of decisions we have to make, and we are going to hear from Judge Zone tomorrow morning and Kim McManus at 11 o'clock.
Great.
And hopefully you can be here and maybe if there's some more questions for you. But we want to get to Judge Zone on H540, then we'll take a break. Then we'll come back and vote on H5 21. And then we'll have some folks on the mental health day who are going to come in and talk about mental health and criminal justice. So
I do want to say I will not be here tomorrow morning because I'm in stuff ops, but if there's questions, I'm always happy to answer them.
yeah,
So, you
absolutely.
know what I could be.
We're probably next day, we're probably going to be getting back to this and hopefully. Yeah. So yes, just changing to H540. Thank you, Judge Zone. If you could weigh in on this. We're just doing a so-called drive-by. We heard this morning, we had a walkthrough. We also heard from Kim McManus and a CJC person as well, Jeannie. So over to you.
All right, so good afternoon, Tom Zone, Chief Superior Judge. If you've already had some individuals tell you about it, I will shorten up my presentation that I gave to the Corrections and Institutions Committee. H540 came from what used to be H645 in this committee, where you created the Post-Adjudication Reparative Working Group. The working group was myself and Derek Medownick from DOC. We had Courtney Whittemore, Neil Fabro, Jeannie McLeod, Damian Barnes, and Casey Viato from restorative justice centers across the state. I had to mention their names because it was an absolute joy to work with these individuals and try to effectuate what your bill asked us to do. And we believe we did that. I was chair of the committee, and the committee relied on information from stakeholders. We reached out to entities that were identified in the act, as well as other entities that included state's attorneys and sheriff's office, attorney general, the Center for Crime Victim Services, and to all the CJCs. And what happened was the group got together, we got the information, we reviewed the statutes, we relied on each other's insights. And I think Derek said it best in House Corrections a couple of days ago, that we believe that we accomplished what you asked us to do in the bill in H645. And if you look at H540, Section 1 is the section that starts what the group did. Essentially, Section 1 does nothing more than straighten out the language into a format that is consistent with the other provisions in Section 7030 of Title 13. And I want to be very clear. The group did not change statutes substantively as far as what was already in legislation. We restructured it. We put things in other areas to make it clearer, to make it work better. And there were areas that were added. And I'll talk about those in a moment. But when you look on page 2 of H540, everything that's crossed out, it's just put somewhere else. It's still part of the law. So we haven't made a substantive change there. This was just a way to take the language that was there that's being crossed out and essentially put it into Title 28, into a new statute that would be a one-stop shopping, if you will, to identify how does post-adjudication reparative probation work in the state of Vermont. Section 2 is one substantive change. The committee does believe that it was appropriate to delete civil contempt of child support orders from reparative probation. That was something that no one could think of ever being used. And so the group's consensus was to remove that. Section 3 is really the meat of what the group put together, and that is, it talks about the ability to order someone into restorative justice program in the case of a conviction. In Section 913A, lines 3 through 7, it talks about what cases qualify. That does not change existing law. It's just put in a different spot. So this does not change who qualifies. Under this bill, it will be the same on June 30th of 2026 as it will be for who qualifies on July 1st of 2026 if this bill were to pass. Line 8 through 13 talks about the referral as part of a sentence. That doesn't change anything. It just clarifies how it works and puts it in a spot where it highlights that you don't have to be on probation to have a sentence of restorative program. And it tells what happens if you don't successfully complete it, that you come back to the court for sentencing. Subsection C, lines 14 and 15, identify that you may, as a condition of probation, have a restorative justice program sentence. Section D sets forth relevant factors for the court to consider when determining whether to order someone to participate in a restorative justice program. This is new. Currently, there are no factors. And so the factors here are a combination of what each of the stakeholders and each of the members had indicated. These are concerns, these are things that we believe should be looked at before someone is sent into the restorative justice program. And so those were set forth in subsection D to identify the judges need to look at that and the parties need to look at that. The language says including, which means it is a non-exclusive list of factors. There may be other factors that are considered. Subsection E is something that provides geographic access all over the state and geographic equality in terms of we're going to have standardized forms if this bill passes. That was something that the CJC has believed was important. And it also adds predictability for what it's going to look like when someone is referred. And then finally, subsection F talks about the court may adopt procedural rules. At this time, I don't know if that would happen, but highlighting it there just makes it clear that if there is a criminal rule of procedure that is deemed appropriate to address this, for instance, we have rules that talk about probation, revocation, sentencing hearings, things like that, that it's clear that the court may choose to do that. The final aspect of this bill that I would note is the cost. Zero. It costs nothing. There is no budget impact. And the view of the committee was that, the working group was that not only is there no budget impact, but it provides clarity and improves what we currently have in a manner that we think will have the post-adjudication reparative programs utilized more than we have now. And it will provide the ability for citizens in all of our counties to have, if you will, equal footing for how things are going to work when you're going into these programs.
Fair enough. So questions? Go ahead, Angela.
Hi, Judge Tony. I just wanted to ask a question that I asked of Ms. McManus, Attorney McManus, earlier today. I'll change it slightly for you, but I'm looking at page 4, line 4 and 5. So in the considerations, the relevant factors. I'm sure you recall that a few years ago, we changed the law so that cases involving domestic and sexual violence could be sent to community justice centers or reparative programs. How can you opine on how a judge might consider whether there are any orders of protection in effect or previously in effect between the offender and any victim?
Well, the factors, when you look on page 3 and 4, the 6 factors, the court weighs them. They're not counted. And I know, so it doesn't have, I know I was asked a question that in another committee where it seemed like there may be a perception sometimes that when you have factors, you have to go through and, okay, you got 4 here and 2 here or whatever it may be. But it's like when we deal with parental rights and responsibilities, you weigh the factors. And so when a court is looking at these factors, the judge would look at, you looked at specifically, you said 5 and 6, or 4 and 5 for number 6, orders of protection. The court has to consider, how does that play into the current situation? Does the victim believe that this is something that the victim wants to go through as a process? Do the underlying facts indicate that even if the victim wants to go through, the judge may still believe that there's a concern for safety that needs to be addressed? Does the CJC, based on the court's experience, has they weighed in on this? And so I think that when you look at these, you can't say there's a one-size-fits-all model for how a judge considers it, but the judge has to look at all the factors and say, is this case, when we have those orders of protection that were here, what were the orders? Was there a violation of those orders? Did the person file them? Is the order now gone? Was the order several years ago and the people are now having what we would call normal contact, after that order, and then something still happened as a crime. And so you have to weigh it out like that.
Yeah, okay, and do you think that when there are factors that the court must consider in your experience, are they, because we're talking about, moving toward consistency across the state in all counties. Not sure this is even fair to ask, but are factors, I would imagine there's training on how to consider the factors and things like that, but how does this go further how does this further that goal of consistency? When to me, it seems to introduce a lot of continued subjectivity.
Because there's always going to be subjectivity when you look at sentences. There's always going to be a weighing of factors. Right now, the way the system works for whether someone's going to be sent, if you walked into any of the 14 counties, there's no list of factors for the judges to consider. There is essentially no baseline of consistency that is built in. This builds that in. So you're actually, while there will be subjectivity, you're reducing the uncertainty and you're bringing into it, these are the factors you have to consider. Now, there may be others a judge considers, but anytime you put these factors in, a judge should be looking at them and essentially, as I'm sure many of you would do, and say, okay, let's look at number one. Let's think about that. How does that go? How about number two, as you're weighing things out? And it also provides the state's attorneys and the defense bar the opportunity to address that. Keep in mind that most sentences in the state of Vermont are sentences that are agreed upon between the state and defense as part of a plea agreement. And so historically, these conditions come to the court not at a contested sentencing, but more often than not, in the vast majority of cases, it's the state and defense saying, Judge, this is the terms, and he's going to do or she's going to do rep board. And so this, I think, puts everyone on notice that there is an expectation of consideration of things that people might not have been considering before when they were resolving cases.
Okay, thank you.
Thank you, Judge. I just want to share my appreciation for you in leading this working group. I can remember when we did the first bill that launched the work group. I remember being disappointed that we couldn't get recommendations like these into that bill. But this is lovely. This is exactly what we were looking for, is to have language to be able to put in there. So I'm glad that it worked out well and that we can keep moving it forward. So thank you.
Thank you. Again, it was an exceptional, I was so pleased, and it was a pleasure to work with the exceptional individuals that were on that working group.
Thank you very much, Judge. Really appreciate it.
Thank you.
So for this particular bill, like I say, we were asked to do a drive-by. I don't know if Alice is expecting a straw poll from us or not, but let me just ask, did anybody have any issues with this? And that might be all that she needs me to tell her. And if she needs more, I will do a straw poll tomorrow, but
Well,
issues?
and why don't we just do a straw poll instead of potentially coming back to do a straw poll? Do it once instead of twice.
Okay, are we all?
I'm just,
Are you setting us up for failure,
Are
Tom?
we are we all fine?
the same message.
All right, I will take a motion to find that we think this is how did we ever decide exactly what I'm supposed to say in straw poll? We approve. We love this. We are endorse the good.
You want me to
work.
handle this?
Yes, you do.
Okay, we're gonna take a straw poll. All those in favor?
What are we doing?
The bill that we.
All those in
It's
favor
not
of the bill as it is.
Sure.
Okay,
You don't know what we're talking about.
yeah, thank you.
No,
Okay.
I do. I just have, I want to flag a couple things for their
You can
committee.
flag, you can flag. You can
Like
flag from you.
stuff that Karen's it's more like in future work.
Do we need more discussion?
No, I think
Will
that one,
report it.
let's flag that as your flags instead of the committee's flags just at this point. I mean, is that right?
Sure.
Because,
Yeah.
yeah, because I mean, if it was like, we recommend changes to the language, that'd be one thing. I understand what you're flagging for 'em.
Yeah.
But, and I agree with that, but, you know, I agree with what you're flagging, but I don't see any language.
I'm glad Judge Sonia is watching this.
Because Judge Sonia did such a fabulous job and we, you know, we're not gonna, that's what they're.
Judge, you're welcome for the entertainment.
Wait, what was the
Well-
result of the straw poll?
It was
Unanimous.
4803, and I will ask Kenny and, well, 803 is fine. Thank you, Judge. And we'll see
Thank you. Have a
tomorrow
great
morning
day.
At 11. We'll see you tomorrow morning, 11 on the,
That phrase good enough for
animal.
her?
That
So
works.
we're gonna go offline for 15 minutes. That means 25 to.
25 minutes?
No, 20.